second recording for ASMR Sleep Station. If you don't know what that is, these are recordings made to help you relax or fall asleep. And ASMR is a condition that some people have. Look it up. The full name is Autonomic Sensory Meridian Response. And you'll find all kinds of things. So, I speak deliberately, slowly, and I try to keep my voice soft in order to help people relax. The first thing I'll do is go through feedback as quickly as I can. There's not a whole lot. That's not a complaint. And because of recent feedback, I'm going to try to keep down the rambling. So, it looks like there's an interesting curve to the episodes that are downloaded. If you look at them on iTunes, there's like a small peak around episode 24 if you lay them out like a distribution, and 13, and of course the first and last recordings. So right now there's 82 reviews, or not reviews, ratings. The distribution from 5 to 1 stars is 68,743. One written review since the last recording, and that was from JenCat395 on September 29th, 2016. It was titled Relaxing to Listen to Anytime. It reads, "Thank you for making this. It's great to listen to anytime I want to relax. You have a great voice. I only listen to the episodes where you're just talking about what's on your mind, with the exception of the episode where you're reading about genetics, because it's something I'm fascinated by and hope to have a career in one day. I love how candid you are. It's great to listen to you talk about everything from movies and how to be happy to sleep disorders and complaining about humanity. Keep up the great work." Oh, thank you for leaving the very thorough comment. I appreciate that. It's very encouraging, even though another comment that I'll get to shortly is kind of counter to this one, in that it I don't know if it's too strong of a word, but I'm pretty sure it criticizes my rambling, so I'm going to try to forego at least excessive rambling and stick to some content. And I don't mind doing that because there's some things that have been on the back burner for a while, and I haven't really been getting to them. The last recording, 31, is a pretty good example of that, because I think I spent almost an entire hour just rambling. So so this one will be different. And that was a 5-star review from Jen Cat. So I really, really appreciate that. It helps. Helps me continue to do this, and I really am doing this for you, the people listening. There's no other reason, and that's probably why it's a little irregular sometimes. But like I mentioned before, this has been a very, very difficult year for me. Actually, it started late last year, and my schedule has been crazy, and I've been busy, and it seems like whenever I'm not busy, I spend a lot of time just keeping to myself and relaxing and I guess tuning out. That's my coping mechanism right now. Another small detail, if I don't know if iTunes matters, that's probably where most people download podcasts from. ASMR Sleep Station is number 40 in the alternative health listing. That's a subcategory, and if I go to health, I think it might be, it's probably off the chart. Yeah, I don't think it's on this chart. So it's below 200 in ranking. This isn't, I guess there's no real meaning to it, but I just like reporting these numerical values for the fun of it. And really, my goal is to say things that aren't necessarily stimulating, so the ranking would be below 200. It doesn't show up. No, that was the last one. There's actually two. There's one from Elena. It says, "Greetings from Moscow. It's 0:20 a.m. I'm a bit drunk and have to get up in 4 hours. Your podcast helped me in this kind of situations. Thank you." You're welcome. If I could laugh, I would do it now. I guess I could try to whisper laugh, but that would be a little goofy in a way. I'm glad that podcast helps you. Hopefully you got at least some sleep. I think 4 hours is good, depending on how drunk you are, but hopefully you got enough rest and sobered up. And hopefully you didn't have to get up for work. Maybe it was something else. That was left on October 5th. Wow, it gives the hours, minutes, and seconds. I think this is in United States Eastern Time. So that was October 5th, 21, 24, 58. And preceding that, on the same day at 1:50:30, that's 1:50 a.m., RJ left a message that reads, "I don't see why you make a deal on you rambling on this one because you seem to ramble on all of them. The all is in capital, all caps, and it's the opposite of relaxing." Again, I think I would insert laughter there. Maybe because I know that that's true in a way, and of course, my rambling isn't relaxing to everybody, and because of that, and because I'm kind of flexible, and I don't think I've rambled too much on this one. I've just been slowly covering feedback. This recording 32 and 33, I think I'll try it for 2. I'll not have any free discussion sessions, and I'll stick to a plan. So I don't know if RJ is still listening, but if you are, thanks. Actually, thanks to RJ and Elena for posting on the website, and I appreciate you both taking the time for feedback. So hopefully RJ will find this relaxing, and I'll start off with something that I've had on the back burner for a while. I actually have a whole collection of things, all kinds of things to read, and let's see. I haven't been exercising as much as normal, and I think my lung capacity has changed. I feel like I'm really holding back, breathing heavily into the microphone. I feel kind of goofy today. Like I'm constantly on the verge of laughing. Oh, and another thing that I should really compile all this stuff and say it all at the beginning, but another thing about these recordings is I don't do anything but edit loud noises out of them, and most of the time they're recorded chronologically, unless I have something that I want to shift to the front, but that usually doesn't happen. Site has 577 US 2015 per curiam. Supreme Court of the United States, Randy White, Warden vs. Roger L. Wheeler, on petition for writ of certiorari to the United States Court of Appeals for the Sixth Circuit, number 14-1372, decided December 14th, 2015, per curiam. A death sentence imposed by a Kentucky trial court and affirmed by the Kentucky Supreme Court has been overturned on habeas corpus review by the Court of Appeals for the Sixth Circuit during the jury selection process for the state trial court. Excused a juror after concluding he could not give sufficient assurance of neutrality or impartiality in considering whether the death penalty should be imposed. The Court of Appeals, despite the substantial deference it must accord to state court rulings and federal habeas proceedings, determined that excusing the juror in the circumstances of this case violated the Sixth and 14th Amendments. The ruling contravenes controlling precedents from the court, and it is now necessary to reverse the Court of Appeals by this summary disposition. Warden Randy White is the petitioner here, and the convicted prisoner Roger Wheeler is the respondent. In October 1997, police in Louisville, Kentucky found the bodies of Nigel Malone and Nairobi Warfield in the apartment the couple shared. Malone had been stabbed 9 times. Warfield had been strangled to death, and a pair of scissors stuck out from her neck. She was pregnant. DNA taken from the blood at the crime scene matched respondents. Respondent was charged with the murders. During voir dire, Juror 638 gave equivocal and inconsistent answers when questioned about whether he could consider voting to impose the death penalty. In response, the judge's questions about his personal beliefs on the death penalty, Juror 638 said, "I'm not sure that I have formed an opinion one way or the other. I believe there are arguments on both sides of it. Up to pet, I believe that, to petition for Cert 126A when asked by the prosecution about his ability to consider all available penalties. Juror 638 noted he had never been confronted with that situation in a real-life sense of having to make that kind of determination. ID at 131A. So, it's difficult for me," he explained, "to judge how I would, I guess, act. The prosecution sought to clarify Juror 638's answer, asking if the juror meant he was not absolutely certain whether he could realistically consider the death penalty. At 132A, Juror 638 replied, "I think that would be the most accurate way I could answer your question." During defense counsel's examination, Juror 638 described himself as a bit more contemplative on the issue of taking a life and whether or not we would have the right to take that life. And at 133A, however, he expressed his belief that he could consider all the penalty options. And at 134A, the prosecution moved to strike Juror 638 for cause based on his inconsistent replies, as illustrated by his statement that he was not absolutely certain he could realistically consider the death penalty. The defense opposed the motion, arguing that Juror 638's answers, despite having some reservations about the death penalty. The judge said that when she was done questioning Juror 638, she wrote in her notes that the juror could consider the entire range of penalties, and at 138A, she further stated that she did not see him as problematic. At the end of her examination, but she also noted that she did not hear him say that he couldn't realistically consider the death penalty, and reserved ruling on the motion until she could review Juror 638's testimony. The next day, after reviewing the relevant testimony, the judge struck Juror 638 for cause. Then she announced her decision to excuse the juror. The trial judge stated, "And I went back and juror's entire testimony, the prosecution concluded with saying, "Would it be accurate to say that you couldn't consider the entire range?" And his response, "I think that would be pretty accurate, so I'm going to sustain that one too." It at 139A to 140A. I didn't realize how much maybe unpleasant topic there would be in this Supreme Court one. So I'm going to, I think I might have another one. I'm pretty sure I have some backup one. So, and I usually talk while I'm looking around for these things. I found the other document that I was looking for. So, sorry that other one got mixed in. I don't think there was anything like horrific in there, but maybe not the best thing to read. So, this is the one that I meant to get. And it seemed like it might be pretty dry. This is titled Reconsidering Reconciliation, A Long Game by Jeffrey G. Hewitt. And this is from a Supreme Court Law Review Journal, 2014, Volume 67, SCLR 2D. I'll be starting on page, I believe, 259. The first section is titled The Introduction. So, kind of on the same very general topic, Supreme Court. And I thought it might be remotely relevant because of, in the United States, there's a presidential election coming up. Anyways, Section 1, Introduction. Chief Justice McLaughlin has identified reconciliation of the relationship between Canada and Aboriginal people as among the court's top priorities in the coming years, but as the court prepared the way, after years, there's footnote 1, which I'll read following the remainder of main body text on the page. Since the meaning of Section 35 of Constitution Act 1982, footnote 2, continues to take shape and is central to reconciling the relationship between Canada and Aboriginal people. What do we mean by reconciliation? This paper explores some of the many ways that Indigenous legal orders may offer assistance to the priority of reconciliation, not only in terms of potentially resolving issues with Aboriginal communities, but also in terms of regulating relationships between Aboriginal and non-Aboriginal communities. So we'll go back and read the footnotes, and I haven't hit footnote 3 yet, but I'll read that one preemptively. I guess footnote asterisk. I think it's a preface. Reads, this paper was prepared for the 17th Annual Constitutional Cases Conference held at Osgoode Hall Law School, York University, Toronto, on April 11, 2014, and relates to broader questions relating to the legal relationship between Canada and Aboriginal people that have been exploring since my arrival at law school in 1993, conceptualizing reconciliation as founded on the equality of all peoples, as set out in the abstract and echoed throughout this paper, is based on Professor Patrick McLaren's thesis in Indigenous Difference and the Constitution of Canada, Toronto, University of Toronto Press, 2001. There are many people to thank for their review of early drafts in this paper. For their wise counsel, they are Professors Sonia got distracted. They are Professor Sonia Lawrence, Omar Bhatia, Dana Scott, Bruce Ryder, John Burroughs, and the anonymous peer reviewers. I'm also grateful for time spent as a McMurtry Fellow at Hoskedal Law School in 2013 to 2014, and being able to spend time with faculty who has been so intellectually generous with me. Footnote 1 reads, see Joseph Breen, Reconciliation with the First Nations, not the Charter of Rights and Freedoms, will define the Supreme Court in coming years. Chief Justice says, National Post, March 13th, 2014, and there's an online reference to a URL. Footnote 2 references Schedule B to the Canada Act 1982, UK 1982, C11, hereinafter Constitution. Footnote 3 reads both D. Newman and Reconciliation Legal Conceptions and Faces of Justice in J.D. White, 80 Moving Towards Justice, Legal Traditions, and Aboriginal Justice, Saskatoon, Puric Publishing, 2008, hereinafter Newman, and T. Pennicut, Reconciliation First Nations Treaty Making in British Columbia, Vancouver, Douglas and McIntyre, 2006, offer further insight into the question of reconciliation of Aboriginal people and the settler population within a Canadian legal framework. Continuing back to the main text, this is now page 260. This paper also seeks to draw links between Section 35, Jurisprudence, and the Indigenous legal traditions based on a collection of scholarship reflecting on both the former and the latter. Sorry, I had to ignore that call. Okay, continuing, though the word reconciliation is possessed of various definitions, uses, and meanings. Footnote 4. This paper considers Professor Mark Walter's reconciliation as a relationship which involves sincere acts of mutual respect, tolerance, and goodwill that serve to heal rifts and create the foundations for a harmonious relationship as the most hopeful vision of possibilities for Canada and Aboriginal people. Walter's description of reconciliation as relationship assists in nuancing the broadly accepted technical legal definition of reconciliation as the renewal of amicable relations between two persons. serious of injuries on one or both sides. In other words, reconciliation goes beyond reconciling Aboriginal title or Aboriginal economic interest with those of Canada and private enterprise. In this paragraph, there's footnotes up to 9. I'm just going to stop reading them, but I will read them as they are on the page. So basically, just reading top to bottom. Reconciliation is a means to bring balance to the relationship between Canada and Aboriginal people, which is too one-sided and has been tense for centuries. Given this, the road to reconciliation is a delicate one and must go beyond the merely symbolic. At the heart of the tension is the Crown's insistence that it is sovereign over Aboriginal people. Indeed, since the passing of the Constitution Act 1982, while the court has made room for the unprecedented degree of protection for certain cultural practices within the state, it has nonetheless repeatedly and steadfastly refused to challenge the racist origin of Canada's assumed sovereignty authority over Indigenous peoples and their territories. Here are the notes for that page. 4. V. Napoleon, who gets to say what happened, reconciliation issues for the Gitxian and C. Bell and D. Kane it's intercultural dispute resolution in Aboriginal context, Vancouver, UBC Press, 2004. 5. M. Walters, the jurisprudence of reconciliation, Aboriginal rights in Canada, and W. Kimwika and P. Bashir, eds. Politics of Reconciliation in Multicultural Societies, Oxford University Press, 2008, Chapter 8, 165 and 70, here and after Walters. 6. ID 7, Black's Law Dictionary, 9th edition, St. Paul, Minnesota, Thomas Reuters, 2009. 8. E. Ria Simas, To What End the Dialogue, in J. Cameron and V. Ryder, editions 2011, 54, SCLR, 2D 493 at 514, year and after Simas sets out concerns relating to the Crown's framing of reconciliation as discussions merely addressing the negotiations of resource sharing or impact benefit agreement. 9. For a discussion on the tension in the relation between the Constitution and Aboriginal people, see J. Burroughs. The AB is in parentheses Aboriginalism in Canada's Constitution, in J. Cameron and S. Lawrence, eds. 2012, 58 SCLR 2D 351, year and after Burroughs and Aboriginalism. 10. K. McNeil, The Meaning of Aboriginal Title, in M. Ash, ed. Aboriginal and Treaty Rights in Canada, Essays on Law, Equality, and Respect for Difference, Vancouver, UBC Press, 1997, 135 at 137, year and after Ash. And I'll just read the remainder of this, and then stop there. So, if you're still awake or listening, feel free to give me feedback and let me know if this content is suitable for you, if you find it relaxing, or if you have any suggestions based on this. I think the only one that I'm still going to continue to go back to from prior recordings is the Candide that I was reading. I think in 2 or 3 recordings. That one seemed pretty good, but I rarely get responses for people liking or disliking any of the text that I've been reading, so I would take that to mean that it works well enough. So, and if you'd like me to ramble more, if that helps you sleep more, then if you haven't already given feedback, feel free to give me that feedback and let me know, because that helps shape the show. And even though I think the majority of feedback that I've received doesn't really have any problems with the content that I read, except when things are interesting, like the comment from Jen Cat. I'm assuming that I don't even remember what I was gonna say, but yeah, I'll still minimize the rambling on the next episode, and then maybe after that I'll go back into more of a free form. I'm not really sure, and I'm not really attached to having a specific format for this show, so different things work at different times, and I try to give consideration and thought to all the feedback that I get. So, anyways, I'll read the rest of this paragraph, and that'll be it. And I'll hopefully get to another recording soon. My schedule is still opening up, and I have less obligations, but that doesn't seem to really make a difference in when I record anyways. So, the mere introduction of European-based laws did not supersede Aboriginal laws. Aboriginal people neither lost nor surrendered their right to continue to develop and maintain their own laws. Put another way, Aboriginal people have been conquered. Nonetheless, the Crown has assumed sovereignty authority over Aboriginal people by means of historical fiction, which in some instances has been propped up by the court. Given this difference of opinion between the Crown and Aboriginal people, is the court able to utilize Section 35 to achieve reconciliation? How is reconciliation to be guided by a court that relies on laws that belong only to one party and that are based on a colonial construct? Alright, that concludes the main text for page 261. If you want me to continue with that, shoot me an email, or if you feel inspired to, you can post feedback somewhere, and I'll read it just the same. But emails I usually don't read in the recording, so let me know I'm here for you and you alone. This is just me doing what I think is relaxing or something that can kind of dislocate your concentration from whatever keeps you from sleeping, and hopefully you're asleep. But if you're still awake, thank you very, very much for downloading this.